Mr. Lade?
Lady, correct.
Lady, okay.
Good afternoon,
Good
Your
afternoon.
Honors. May it please the Court. Joshua Lady with the Appellate Public Defenders here for Mr. Tommy Hollingsworth. I'd like to reserve 3 minutes of my time for rebuttal, if I could. We have raised 3 issues in this appeal. I'd like to focus today on the first 2 as they appear in the briefings. That's the speedy trial issue and the due process notice issue. I'm, of course, happy to answer questions about our 3rd issue as well, if there are any. So I want to start with just a very brief factual summary. This is an appeal from the revocation of Mr. Hollingsworth's probation. He was placed on this probation on October 19th of 1998. He successfully reported for just under 4 years until July 8th of 2002. On that date, a violation warrant was filed alleging 4 violations that today would be technical violations. And that warrant was the last thing that happened in this case until December of 2024. On that date, he was reporting to probation in Texas, a different probation, and his officer there informed him that a warrant had popped up on his account and he was needed in Tennessee to resolve this case. So he was then transported back and his probation was revoked in March of last year. So we have raised a speedy trial challenge to the delay between the issuance of the violation warrant in 2002 and the revocation of Mr. Hollingsworth's probation. A significant amount of the briefing in this case has been about this question of when speedy trial rights attach in this context. The Tennessee Supreme Court just a few weeks ago granted an appeal on that exact question in State v. Moon. So my inclination today is to leave that issue to the briefing because it seems likely the Supreme Court is going to answer that question for us in the near future. So I'll just move forward on the speedy trial issue, assuming we're dealing with a 22-year delay, because I concede we don't have a claim if it's the other way, because it's a delay of 3 months in that case. So moving to the second Barker factor, the reason for the delay. The cause of the delay in this case was the state's failure to file a detainer on Mr. Hollingsworth's account in NCIC. Filing detainers is standard practice, even in probation cases, and a properly filed detainer would have meant that at any time during those 22 years, if Mr. Hollingsworth was involved in another criminal case, as he was, it would have popped up in the system that those other state authorities were using and said that Mr. Hollingsworth was needed here in Tennessee to resolve this probation violation. Because there was no detainer, that never occurred, hence the 22-year delay, which...
would your argument be that if the state had filed a detainer and your client had never gotten in trouble for 22 years, and when he did finally get in trouble after 22 years and it popped for the first time, that there's no longer a speedy trial issue?
I think at that point, the analysis under the second Barker factor weighs more strongly in favor of a finding that the delay was caused by Mr. Hollingsworth's absconsion. Here we have Mr. Hollingsworth certainly stopped reporting after 2002. I don't contest that fact.
Right, yeah. I was just trying to, you seem to be that if the state had just lodged the detainer on day 1, day 2, whatever, so to speak, that at that point, it kind of covers the state, very generic terms here, right?
Sure.
But covers the state, and it becomes, it's the defendant who then has to show, hey, whereas if the state doesn't file a detainer, then the defendant can abscond and get in trouble all he wants, right, and doesn't have to come back.
Right. The filing of the detainer is really just the bare minimum thing that the state typically does in these kinds of cases to make sure that they're resolved in a timely manner. That didn't happen in this case for reasons that are unclear from the record, and hence the 22-year delay. So the second factor should weigh in Mr. Hollingsworth's favor. Just briefly on the third factor, the assertion of the right, Mr. Hollingsworth asserted his right to a speedy trial almost as soon as he was brought back to Tennessee on this case. And then as to prejudice, the fourth factor, I will just highlight that when we're dealing with a delay of as exceedingly long as this one, 22 years, there is kind of a presumption that this prejudiced the defendant because this is an excessively long delay, even for speedy trial cases.
So the warrant was 2002, the probation
Correct.
warrant that's here. All right. What does the record show happened between 2002 and the Illinois incarceration? I think that was 07.
Nothing. I don't believe there's anything in the record about what happened between the issuance of the warrant in 2002 and Mr. Hollingsworth's arrest, I believe, on a burglary charge in 2006 or 2007.
All right.
I believe the record is silent on that period. So a 22-year delay is excessively long, but we do actually have particularized prejudice here. Ms. Manis, who's the probation officer, testified at the revocation hearing that she could not recall, because of the passage of time, whether Mr. Hollingsworth accepted responsibility for having used marijuana. And my reading of the state's brief is that it concedes that whether Mr. Hollingsworth accepted that responsibility would have been relevant to the trial court's decision as to consequence under the second prong of Dagnan. So we have both presumptive prejudice and actual prejudice here, and so all four Barker factors weigh in Mr. Hollingsworth's favor. If there are no other questions on that, I'll move to the due process issue. We have raised this issue under plain error. The state has contested two of the plain error factors, that a clear and unequivocal rule of law was breached and that correction of the error is necessary to do substantial justice. The clear and unequivocal rule of law that was breached here was the lack of notice that absconsion would be at issue as a basis for violating Mr. Hollingsworth's probation. As I mentioned earlier, the violation warrant from 2002, which was the only violation warrant filed in this case, alleged 4 violations, which now would be technical violations. None of those are failing to report or absconsion or anything in that genre. And so there was no written notice here. In the context of probation, actual notice may be a substitute for written notice, but there is no actual notice here. The first mention of absconsion in the record was the trial court's sua sponte finding that Mr. Hollingsworth did abscond.
So let me ask you this.
Sure.
Assuming we say you're right, there was no notice of absconsion, that one's out. The other violations, while technical now, at the time, were treated differently. At the time that he was in violation, those would be a basis for revocation as non-technical violation. I mean, it'd just be non-technical violation.
Sure.
The law has changed since then, but at the time he committed those violations, it was different. Does that change our analysis?
Not at all. I believe it's in the technical, non-technical statute itself, or it may be somewhere else, that says that courts apply the technical, non-technical distinction even if the violations occurred prior to that change in the law. So the analysis is the same. Your Honor is correct. Without absconsion, there were only technical violations remaining. And because this was the first instance of technical violations, the trial court was without authority to revoke Mr. Hollingsworth's probation at all.
So he's without authority to revoke completely.
To revoke at all is my reading of the statute. This is TCA 4035. I believe it's 311 D2 says for a first instance of a technical violation or violations, the trial court may not revoke probation, which is what we're dealing with here. This was the first time technical violations.
I'm sorry.
So if there are no other questions on that, there was one other issue that we didn't raise separately that I wanted to bring to the court's attention. We mentioned this in footnote 3 on page 10 of our brief. This is an issue about the sentence that Mr. Hollingsworth is currently serving. The original sentence was for 2 consecutive 3-year terms. The violation warrant was not issued until almost 4 years after he began serving that sentence. So there was only a single 3-year sentence remaining when the violation warrant issued. The other one had expired because he had finished serving it. When the trial court revoked probation, it revoked Mr. Hollingsworth to serve 6 years. when it only had authority to impose a sentence of 3 years, because that's the only sentence that was remaining. We have attempted to address the issue with the trial court during this appeal's pendency, and the trial court threw a Rule 36.1 motion, and the trial court said it was without authority because the appeal was ongoing, that it didn't have jurisdiction. I recognize if the court feels that we haven't properly preserved that issue, we can address it with the trial court after. Just for the sake of judicial economy, I wanted to bring it to the court's attention.
So Mr. Hollingsworth is in custody?
He is currently in custody. The reason that we didn't raise it as a separate issue is because when I filed the principal brief, the felony offender reflected a sentence of 3 years, and so it appeared to me that sentence management had caught the issue on the back end. That is no longer the case. Felony offender now shows a sentence of 6 years, which is what led to that. If there are
Let me
no
ask you this.
Sure.
Based on what our Supreme Court has recently done and the statement you made at the beginning, and that is they've taken this issue up, and you made the statement that, we may know what the answer is here in a while.
Mm-hmm.
But your client is currently incarcerated.
Yes.
Have you tried to seek some sort of probation again, just pending the outcome out of this, a bond of some sort? I mean, have you tried to get him out pending the Supreme Court resolution? Because by the
Hollins-
time the Supreme Court resolves it,
Sure.
they may resolve it in your favor, but he's served the remaining 3 years.
Sure. So Mr. Hollingsworth is currently up for parole, I think, in 2 days, so it may
resolve
end
itself.
up resolving
Okay.
itself at that time. So, thank you, Your Honors.
Good afternoon, Your Honors. One last time today. Benjamin Barker on behalf of the state. Your Honors, this court should affirm the trial court's revocation of defendant's probation because the trial court properly denied his motion to dismiss on speedy trial grounds. Judge McMillan, I know that we disagree.
We do.
And
It is what it is.
we'll find out who's right soon
We
enough.
will. It's okay, it's okay.
I understand. So it's just the state's position that the clock for speedy trial purposes started here when he was arrested.
So then let's just go ahead and go to the notice issue, right? We know your position, we know defense counsel's position, we know the Supreme Court's going to look at it. If he doesn't have notice of absconsion, and all he has is 4 technical violations, what's the basis for revocation?
Because it was four instances of technical violations that justified the trial court in fully revoking his probation. Now, they were all under one warrant, but it was 4 separate instances. He failed to pay his supervision fees, didn't pay his court costs. Then in June 2002, he failed this drug test, and he quit his job without permission in May of 2002. And this court has espoused a similar view or a similar interpretation of instance in this context in State v. Carney, which is cited in the state's brief. It's the state's position that despite the notice, the alleged notice issue, there were still 4 instances of technical violations that justified the trial court in fully
So
revoking
warrant,
defendant's
so the
probation.
state's position, which is that a warrant doesn't create 1 instance, it may cover 17 instances.
That's correct,
And
Your
if
Honor.
that's the case, he can fully revoke.
That's correct, Your Honor. Defendant claims that the trial court violated his due process rights by relying on absconsion. He's here under plain error. It's the state's position that all of the Dagnan stuff here is waived because defendant, reasonably so, I think, focused his efforts below on the speedy trial claim and just didn't address either of the Dagnan prongs with the trial court at this hearing. Maybe that was reasonable, but it results in waiver of these claims on appeal. And ultimately, as for the notice issue, there's no, as I think we've talked about now, I don't mean to kind of talk in circles, but there's no plain error here because it's not necessary to do substantial justice. At base, defendant committed 4 instances of technical violations, which was sufficient to fully revoke his probation. So any reliance on absconsion was harmless here, and the trial court properly relied.
In the trial court, let's say he did just rely on the 4 technical what we would call technical violations now. But since it's 4 instances and he revokes, can he rely on absconsion in determining disposition of that revocation?
I don't see why not. It's certainly a factor that the court can consider. If it's going to be a basis for revoking itself, then yes, that would need to be, notice is required for that. But just for the consequence, it seems to me that the trial court can take a broader world of information into account in determining what the appropriate consequence is for a violation. Does that answer your question, Your Honor? I anticipated we spend a little more time talking about the funds
your argument
issue,
today,
but they yanked it away from us.
I'm kind of glad, that they,
I understand. It's certainly easier for them to just say once and for all what it is, so we can quit fussing about it down here. At the end of the day, the state asks this court to affirm. Thank you, Your Honors.
Thank you, Mr. Parker. You have your 3 minutes for rebuttal, Mr. Lady. Lady.
Thank you, Your Honor. I just want to talk briefly about Carney. It is our position that Carney was incorrect. Before I talk about Carney, though, with what time I have, I do just want to bring the court's attention to the next subsection of that same statute. D2 says can't revoke for a first instance of technical violations. Subsection E1 says that for a first revocation, the maximum sentence that can be imposed is 15 days. And this was undoubtedly the first revocation because Mr. Hollingsworth had never been brought in on this case before. And so the maximum thing that the trial court could do without absconsion with any number of technical violations at issue at once was 15 days. Now, on Carney itself, we don't believe that Carney carries a significant amount of persuasive authority. The reasoning in Carney basically consisted of reciting the party's positions and then saying that it agreed with the state because otherwise defendants could flaunt the rules of probation by committing any number of technical violations, and then they can't be revoked if it's all dealt with at once. Our position is that the statute 4035-311 D2 reads much more simply if we read instance to mean any number of technical violations that we're dealing with at a single revocation hearing. Because the statute reads instance of technical violation or violations, meaning that there can be multiple acts that constitute a single instance under the statute. And figuring out what that means would require a significant factual inquiry about how do you commit multiple acts in a single instance, how do you delineate when that happens, and all of that for what are ultimately technical violations of probation. And it seems unlikely to me that that's what the legislature intended. I think the far more elegant reading of the statute is instance means what are we talking about right now? And if it's the first time we're talking about it, then you can't revoke probation for technical violations. So that's what I had to say about Carney. If there are no other questions, respectfully ask this court to dismiss the warrant against Mr. Hollingsworth. Thank you.
Thank you, Mr. Lady. All right, we appreciate the briefs, the argument of both parties. The matter will be taken under advisement. I understand that we have one other matter before we adjourn for today. We're going to take about a 5-minute recess so we can change out panels. This will be my last time seeing you guys. I do appreciate all the parties for today. Thank you.
All right.